Please allow me to introduce Dr. Jack. He is an assistant professor of law at the School of Law, SMU. He graduated from NUS in '95 and practiced for about 6 years as a litigation lawyer before completing an LLM at University College London in 2003 on a British Chevening scholarship. In 2012, he was conferred a PhD for research into the interpretation of bills of rights by the University of Birmingham. He joined SMU in 2008 and teaches research, constitutional and admin law. He also has an interest in the law of cultural property and heritage. He was a 2009 Lee Foundation Fellow for Research Excellence and won the School of Law's Most Promising Teacher Award for 2010-2011. He is a member of the Law Society of Singapore's Public and International Law Committee.
Good afternoon and thanks for coming. I've been asked today to speak about the limits of freedom of speech in the Constitution, but I thought I would go a bit wider since I'm the first speaker and sort of set some of the discussion about some of the issues that may arise if you are a blogger and interested in this subject. Okay, so what I'm going to talk about today is essentially the perils of the online world, as I was asked to talk about, and I thought I would give an overview of some of the legal issues that would arise. I'll talk about civil or non-criminal liability, primarily copyright and defamation. And then I'll say a little bit about criminal liability, contempt of court and sedition and similar offences. Some of these topics will be expanded on by the other speakers, so I'm really just going to touch and go, so to speak. I'll talk about some of the regulatory requirements, and then I will then see how this relates to the scope of freedom of speech and expression under the Constitution, which is the subject that I teach at SMU. Okay, so copyright overview. So, obviously, I think you cannot have escaped the fact that things are copyrighted in the world. We have a copyright regime in Singapore as well. If you are an author, and an author of work such as an artistic work, a literary work such as a piece of text, or a musical work, so this will include images, text, logos, then copyright actually lasts for a very long time. It lasts for 70 years after the author's death. So you've got to wait till the author passes away and then count 70 years after that. So it lasts for a very, very long time. Now, this is for works that are produced by authors, but there are some works called entrepreneurial works. These are works which are kind of put together by organizations and companies, and these will include sound recordings, films, and so on. So this would include MP3s, video clips, and so on. Now in this case, for entrepreneurial works, where the works are actually authored by a person, then the copyright lasts for 70 years after first publication. And governmental works are copyrighted in Singapore. In some countries, all governmental works are in the public domain, not so in Singapore. All governmental works are copyrighted from 70 years after publication. So why am I telling you all this? Well, if you're going to put any material that you did not create yourself on the internet, then if you do it without permission, then it could be a breach of copyright. There is a doctrine known as fair use. So you can make fair use of certain things. That means if you make some small transient use of an item, maybe it's not a problem, but I would be very doubtful whether putting something on a website pretty much permanently, it just stays there, would amount to fair use. So here's the case. 2008, the blogger Dawn Young, I understand she's quite famous, I don't really know, I have not read her blog, but she was accused of having plagiarized other authors on her blog. So in more than 20 posts, someone actually went to count, she had copied from PM's National Day Rally speech, she copied from an interview by Stan Lee, the creator of Marvel Comics characters, and so on, and this was pointed out to her. So technically this is a breach of copyright because she didn't own these items. So Dawn Young apologized and said, I didn't realize it was wrong, I didn't realize I had to cite my sources, but she was criticized for this. I don't think anyone actually bothered to sue her though. So copyright will be infringed when you download a file from the internet and upload it onto a blog. Or if you even simply add a link to the file on your blog, rather than a link to the home page of the website, such that the file looks like it's part of your blog. This is very easy to do if you know anything about the internet. That is one thing. And another thing which is possibly problematic is if you have material that is in breach of copyright and then you link to it. So you tell people, well, I'm going to put it on my website, but here's where you can find it. Here's the links to all the full versions of movies and all that. That may itself be a problem because you could be facilitating infringement of copyright by other people. So that is also unlawful. And there's actually no Singapore case yet, but there's an Australian case from 2005 called Universal Music and Cooper. And what happened was the defendant decided to run a website consisting entirely of hyperlinks to unauthorized music files for other people to download. So I'm providing a service. I'm telling everyone, here's where you can get free music. Okay? Unfortunately, this is going to be problematic, and in Australia, he was found guilty of infringement of copyright. Okay, so what do we learn from this? Just because you can find a work on the internet does not mean it's in the public domain and can be reproduced in your blog. Oh, it's there on the internet, therefore there's some permission to use it. Not true. Secondly, just because you use it and then put copyright by someone else is also not a solution to the problem, because the person didn't give you permission to do that. So merely taking someone else's picture, putting it on your website, and then putting copyright by XYZ is actually doesn't absolve you from the fact that you have actually copied and taken it in breach of copyright. So the advice is you can use copyright-free materials, obviously. Works that you created yourself, take your pictures, put them up on the website, no problem. You might be able to use graphic collections on CD-ROM, but then you have to check the terms of use. They are somewhere on the box or somewhere hidden in the CD, and they will normally say what you can do with the images. You may be allowed them to use them on the website and so on. Or you use Creative Commons material. What is Creative Commons? Creative Commons is a licensing scheme that was started way back in 2001 by some US academics. And essentially what happens is that they encourage people, when they create works, to license them under what is known as a Creative Commons license. So a Creative Commons license essentially says you can use it under certain conditions, but more or less it's very broad use. So where can you find such Creative Commons material? You can find some on Flickr. Sometimes you go to Flickr, you will see some of them will be copyrighted, but some of them will have a different symbol which says, yes, you can reuse it. So look out for those sorts of materials. And also there's a website called the Wikimedia Commons. This is a website that's related to Wikipedia, which is a resource for freely available Creative Commons and other sorts of public domain graphics and so on, music and so on. Okay, so what about YouTube? Well, you can actually embed YouTube videos in your blog if, number one, the videos do not breach copyright. Means they are not obviously ripped from some movie or some DVD and then put out by someone. And the people who have uploaded the videos on YouTube have enabled the embedding function. There's actually an embedding function which says this video can be embedded in some other website. When they do that, there's actually an implicit consent to other users that you can do so, but you can put the video on your website and embed it in some way. So this is what you can do lawfully. Now I'm going to talk about defamation. I understand that Peter is going to say more about this, so I'm going to say very briefly. What is defamation? Again, I don't think that this would be a big mystery to all of you. Defamation law protects a person from untrue statements that harm his reputation with other people. So the classic definition is publication of material that reflects on a person's reputation so as to lower him in the estimation of right-thinking members of society generally, or which causes him to be shunned or avoided. If you publish a statement which makes someone else think less of the person that you're talking about, then that could be defamatory. So, another example, Wendy Cheng, I think we all know her as Xia Xue. So she posted disparaging remarks about Don Yang, whom I referred to just now, containing some entertainment contracts and endorsement deals that she had entered into, and said, I don't like to be compared with Yang. Then next thing you know, in July 2008, Yang has got a lawyer to send her a letter of demand saying, you have defamed me, and I want an apology, otherwise I'm going to sue. So then Xia Xue had to delete the offending blog entry, but by that time, of course, when you put something on the internet, it's very hard to withdraw it. People had already copied it, forwarded it to other people, taken screenshots of it, reposted it elsewhere, so it's very, very hard to control. And Xia Xue then said, I'm not going to apologize, sue me if you want to, but it seems that nothing came out of it, because I don't think we really heard more about anything. But it just shows that people can get very upset with things that you say about them on websites, so you could put yourself at risk. What if I post something and don't put my name there? Surely that's safe, right? Then they can't trace it back to me. Well, it is troublesome, but if a person is determined enough, they can actually issue legal proceedings against the ISP, like Singtel or Sahab or something like that, and say, I want the identity to be revealed. I want to know whose account it came from, and so on. So if they are willing to do so, the ISP will most likely say, okay, right? I got a court order against me, I'm going to reveal who it is. So it will not be so easy to get away with it if the person is determined. Of course, many people may just say, it's too much trouble, I'm not going to bother. But if you really upset them, who knows? So the advice is, of course, do not make disparaging remarks about identifiable people on your blog. And you can also be reliable for republishing a defamatory statement made by someone else. So it's not a defense to say, XYZ said that this person is a real idiot, blah, 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 because then you can be liable for having republished what XYZ's defamatory statement was there. So therefore, if people are allowed to leave comments on your blog, you actually probably do have to look through these comments from time to time and delete anything that's potentially defamatory, because otherwise they will find you liable for having republished the comment. Now we turn to the criminal side, and I want to talk today about two possible criminal offenses that might arise. One is called scandalizing the court, and Chen Zi will be saying more about this, so again I will just touch and go and not go into this in a lot of great detail. So scandalizing the court is actually a type of contempt of court. Contempt of court is intended to protect public confidence in the administration of justice. So the idea is that there are certain acts that you should not do and statements that you should not make, because this tends to bring the court into disrepute. And if people lose confidence in the court system in Singapore, then we'll be in big trouble because people will not trust judgments by the judges and so on. So there needs to be some form of protection for the courts. Okay, so what is scandalizing the court? Well, scandalizing the court will happen if you make a statement or carry out an act which alleges that there is bias, lack of impartiality, impropriety, or any wrongdoing concerning a judge in the exercise of a judicial function. And so this could also, of course, be an actual statement. I think the judges are biased. Or it could be an action. As you know, there was a case a while back where 3 activists wore white t-shirts with pictures of kangaroo on it, and they said, this is a kangaroo court. They stood outside the Supreme Court. So obviously, it's very clear what they were alluding to, and they were found guilty of scandalizing the court as well. It is not an offense if the criticism is fair. When will criticism be fair? Number one, the law in Singapore requires the criticism to be expressed respectfully, temperate, and dispassionate. So if it sounds like it's abusive, if it sounds like it's very rude and snarky, then it may not satisfy this requirement. The second requirement is that it must be made in good faith. So what sort of things will show that you are doing it in good faith? The primary thing, I think, is that are there any arguments or evidence backing up your statement? Or is it just a bare allegation, I think that this is the case and there's no backing and basis for it? Then chances are you will not be able to rely on fair criticism. So the advice I would say is, in the first instance, if you can avoid it, don't make statements that allege the courts judges are biased, unfair, or unable to hear cases properly, because then this will probably land you to trouble. But if you really do wish to make a statement, then you have to phrase it in respectful terms, and you have to back it up with arguments and evidence. Okay, what about another offense that has been in the public eye fairly recently? Sedition. Sedition is an offense under a special act called the Sedition Act, and it is defined as something which has a tendency to do one of 5 things. So it's actually quite wide. Now most of these things, I guess, will probably not arise, because I doubt if you would do something like that. Number 1, to bring into hatred or contempt or excite disaffection against the government. We should overthrow the government. Okay, that could be problematic. Number 2, to excite the citizens of Singapore to do something that to do by unlawful means something. So you incite people to, we should all storm the shops on Orchard Road and loot them. Okay, then you could get in trouble as well, because clearly that you're inciting people to do something that's unlawful. To bring into hatred or contempt or excite disaffection against the administration of justice. So again, something that might be contempt of court could also be sedition. Number 4, to raise discontent or disaffection among citizens of Singapore. So again, to stir people up about some issue such that they end up rioting or something like that is sedition. And I guess this is the one that has the most has been applied most recently, and you hear about the cases, to promote feelings of ill will and hostility between different races or different classes of the population in Singapore. So here is where you get all those cases of people feeling very unhappy about things that they read online, comments that people have made, oh, it's criticizing my community, and therefore, next thing you know, police reports have been made and police are investigating an offense. So this is, I suppose, something that you have to watch for. This is quite a serious offense. For a first offense, a fine, maximum fine, I should point out, is $5,000 or imprisonment for a term not exceeding 3 years or both. Obviously, this is the maximum. It's the first offense, you would probably just get a fine of some kind. But if it is serious, it makes serious allegations, who knows, you might get a short jail term. And if it is a subsequent offense, then it goes up to imprisonment of 5 years. Now in Singapore, so sedition cases in Singapore. 2005, 3 bloggers were charged and pleaded guilty under the Sedition Act for posting racist anti-Muslim comments. This is the case about criticism of a Muslim lady who had said, oh, you know, dogs should not be allowed in taxis because they dirty the taxis, and under certain schools of Islam, which the Shafi school of Islam, which most Muslims in Singapore belong to, the teaching is that contact with dogs alive is prohibited, but they then posted racist remarks criticizing her view about carriage of dogs in taxis. Then the year later, in 2006, there was a Singapore blogger who then posted insulting cartoons of Jesus Christ on his blog. This time he wasn't charged, but he was given a stern warning. So they said, don't do it again, otherwise you will get charged the next time. So most recently, Amy Chung case, I think we've all heard of this. Police reports have been made. So far, police are presumably investigating. We don't know whether they will see it as serious enough to actually take action against her, or whether it will merely just be a case of another warning against her. But it happens. People do get upset by things that they read, and they make police reports. Personally, I don't think it's a very good thing. I think that people should develop a thicker skin and to say, you know, the way to respond is to say, I disagree with your point, and express your disagreement in a similar way, you know, by posting other comments and so on. But there is a tendency in Singapore for people to pick up the phone and dial 999 for some reason. And so long as that happens, then there will always be the risk that there will be investigation and possible criminal offense charged under this. Now, there is actually a new, similar criminal offense that was introduced in 2007 when the Penal Code was reformed. And this is the offense of promoting enmity between different groups on the grounds of religion or race and doing acts prejudicial to the maintenance of harmony. So it's actually quite broad. And it says that it is an offense by words either spoken or written, or by signs, or by visible representations or otherwise, which I think would clearly cover blocks, to knowingly promote or attempt to promote on the grounds of religion or race disharmony, or again feelings of enmity, hatred or ill will, to say that familiar phrase that you see in the Sedition Act, between different religious or racial groups. So the offense is different from sedition because it extends specifically to grounds on the basis of religion as well as race. In the Sedition Act, it merely says different on the basis of race or different classes of persons, which is not defined. So of course religious groups can be a different type of class, but here we now have an offense that specifically mentions religious groups. And it's quite wide because any act that a person knows to be prejudicial to the maintenance of harmony between different religious or groups, or which disturbs or is likely to disturb the public tranquility, is an offense. So you just have to make a sort of statement which causes some disquiet, and in a sense you've disturbed the public tranquility and it could be an offense. So it's quite a wide-ranging sentence. It seems to be a lesser sentence. The punishment is up to 3 years or fine or both. So that is the new offense that could be used as well. So again, the advice is, if you can, do not post on your blog comments that cause offense to people of other religions or races. And if other people have posted these comments on your blog, then I think you would have to think carefully about removing them. Okay, now I'm going to talk a little bit about regulation. How is the internet regulated in Singapore? The main regulation is under what is known as the Broadcasting Act. Actually, the Broadcasting Act is very broad. It includes radio, it includes TV, but it also includes the internet. If you look at the Act, computer online services are defined as licensable broadcasting services. So, what is the license required? Well, there is something called the Broadcasting Class License Notification. And the good thing to know, or a bad thing to know depending on you, is that you are all automatically licensed already. You don't actually have to do anything. You are deemed to have been licensed under the Act by setting up a website. Okay, so all content providers such as bloggers are automatically considered to be licensed, and therefore you have to comply with two pieces of regulations called the Class License Conditions and the Internet Code of Practice, which are issued by the MDA, Media Development Authority, which is a statutory board under the well, what used to be MICA. I think now it's all changed already, so I think it's now Ministry of Information and Communication, if I'm not mistaken. Or Communication and Information, FCI, I think it's now called. So I'm not going to go through what the Class License Conditions and Internet Code of Practice requires. If you want to have a look at MDA's website, it's all stated there. Basically, it will be very obvious things like, please don't go and post pornography, please don't go and post offensive statements to people, that sort of thing, I think would be the case. But in addition to this general assumption that everyone is licensed, it is mandatory if you are an ICP or Internet Content Provider to register with the MDA, or if the authority approaches you and says, we want you to register, to make a registration if you are providing any information about propagation, promotion, or discussion of political or religious issues relating to Singapore on the World Wide Web. So technically, if you're going to discuss anything that relates to politics or religious matters on the internet, you actually need to license within 14 days of putting out your website with the MDA. I don't really know how many people do this, and I don't know how often MDA actually approaches people and says, I want you to register. I have no idea. But there's this requirement, and if you are not so registered, then you can be fined, you can be suspended, the license can be cancelled. If you have breached any time the license or code of practice, then action can be taken against you by the authority. It's an offence to provide a service without a license if your license has been cancelled, and the penalty is very high. Again, this is the maximum, but I don't know of anyone who's actually, like a blogger or anyone who's actually fallen afoul of this, so I don't know. But it seems very, very severe. And then of course you've heard of the Political Donations Act. Now, the Political Donations Act will really only be relevant to you if you take donations from foreigners for the purpose of running your website. Under the Political Donations Act, the Prime Minister can declare any organisation whose objects or activities relate wholly or mainly to politics in Singapore to be a political association. So the aim was to, when this act was brought into force, was to prevent foreign groups from interfering in domestic politics. And as you know, last year, the Online Citizen was gazetted as a political association. Now, what can political associations do? They can only receive donations from Singapore citizens above the age of at least 21 years of age, and Singapore-controlled companies which carry on business wholly or mainly in Singapore. Therefore, anyone who doesn't fall within either of these cannot give you a donation. And what about if the donation is anonymous? Well, what the law provides is you can only receive anonymous donations which amount to less than $5,000 in any one financial year. Anything above that is unlawful. You have to declare the name of the donor. What happens if people make these donations and you don't know who it's from, so you have no idea whether it's a foreigner? You must return them, or you must forfeit them to the government. Okay? So this is the requirement as well. Yeah. So what else must you do? Political associations must submit an annual report to the Registrar of Political Donations, and you have to declare, and this is really for large donations, any single donation that is $10,000 or more must be declared from who it is and so on. And the donations, let's say, okay, you tell your donor, don't make a $10,000 donation. You don't donate $2,000 to me over a period of several months. No, it doesn't work either, right? As long as the total amount in one financial year is $10,000 from the same donor, actually that donor is also required to. And to make sure that this is done, the donor is under a responsibility to make a separate declaration to the registrar as well. So if one doesn't, and hey, how come there's a declaration from the donor and no declaration from the political association? Then the political association will get in trouble. Okay, so this is to ensure that very large donations are disclosed and they know who it is. There's some, I suppose, some to discourage people from making anonymous large donations that we do not know where they're from. So the advice is, if you really do not need to, then don't take any donations. But and especially from non-citizens and from foreign companies and organizations. If you do, and then it appears that your website is controversial in some way, then you may be asked to register under the political association. You may be gazetted as a political association and then be required to comply with all the requirements under the Act. Okay, so finally I'm going to talk about the effects of the Constitution. Constitution is the supreme law of Singapore. What does it mean to have something called the supreme law of Singapore? It means that any ordinary statute that is inconsistent with the Constitution is void. And it is for the courts to determine whether it is void or not. So Part 4 of the Constitution actually contains what is called the Bill of Rights. And the Bill of Rights is a list of fundamental liberties that are guaranteed to people. So one of them is Article 14.1a. 14.1a says every citizen of Singapore has the right to freedom of speech and expression. Now note the italicized term citizen of Singapore. In a case involving Dow Jones, which is a foreign company, which publishes, I think this case involved the Asian Wall Street Journal. It was held that, well, Dow Jones is a foreign company, and therefore it cannot rely on the right to freedom of speech and expression in the Constitution because it's not a Singapore citizen, and none of its staff members were Singapore citizens as well. And in that case, you could also say, can a company be a citizen? Isn't citizenship a thing that, a status that only individuals, people can hold? So that might be another problem as well. And a similar ruling will be in the more recent case of Review Publishing against Lee Hsien Loong. Review Publishing again publishes one of the major newspapers, I can't remember which one. I think this is Wall Street Journal, if I'm not mistaken. So similarly, Wall Street Journal is not staffed by Singapore citizens, and this means that they could not rely on Article 14 directly. Okay, so we've got Article 14.1, I have to reproduce it again, but we have to contrast that with Article 14.2a. And 14.2a provides situations in which the right to freedom of speech and expression can be limited by Parliament. And as you can see, it is a very long list. Parliament can, by law, impose restrictions as it considers necessary or expedient in the interest of a lot of things. Well, number one, national security. Number two, friendly relations with other countries. Public order, morality. Restrictions designed to protect the privileges of Parliament, to provide against contempt of court, defamation, or incitement to any offence. So basically what this means is that it appears that Parliament can essentially pass laws which are supposed to serve one of these purposes, like to protect national security, to protect people's reputation, and so on. How widely or narrowly is this interpreted? Well, we have a case called Chi Seok Chin, 2006 case. And in the Chi Seok Chin case, this was involving Chi Seok Chin and some activists who went in front of the CPF building and held a protest, I think without a permit. And they were asked to disperse by the police and said, you're not supposed to be here, you have no permit. What they then did was they took action and said that the order by the policeman for us to disperse violated our right to freedom of assembly. Actually, it wasn't a freedom of speech case, it was a freedom of assembly case. But the restrictions on freedom of assembly are very similar to those in freedom of speech, and the court said, let's look at the phrase as it considers necessary or expedient. Well, we think that this actually gives Parliament a very wide discretionary power and remit, which permits a multifarious and multifaceted approach towards achieving any of the purposes specified in Article 14.2. So what does that mean? Basically, they say that since the Constitution says Parliament can by law restrict the freedom of speech or freedom of assembly, as it considers necessary or expedient, it can do so in pretty much any way it wants to. And it will not be unconstitutional for it to do so. I mean, as it considers expedient, what does expedient mean? Convenient. So long as the government thinks it's convenient for freedom of speech or freedom of assembly to be restricted, pretty much it will be allowed to do so, and the courts have said, well, you know, it says that they can do it so long as it's expedient, so it's not for us to then say that it is unconstitutional if they choose to do so. The court went on to say in that case that you know that Article 14.2 doesn't say the word reasonable. So the restrictions don't actually have to be reasonable. If it says Parliament can by law impose reasonable restrictions, then of course the court would have the duty to determine, is this restriction reasonable, is it proportionate? But because it does not contain the word reasonable, a restriction can theoretically be unreasonable or disproportionate, and it will still be constitutional. So this is one of the big ironies of the way, perhaps the way in which the Constitution is drafted, as well as the interpretation of the courts. So the court really doesn't have to apply any test to ensure that restrictions are proportionate or reasonable in any way. On the other hand, we have a recent case called Yong Wei Kong, 2010, where the court suggested that legislation that is unconstitutional, which is legislation might be unconstitutional if it is so absurd or arbitrary that it could not possibly have been contemplated by our framers as being law. So they seem to be more willing now to infer principles into the constitutional text, even though the words are not there. Obviously, the Constitution doesn't actually say any law that is absurd or arbitrary shall be void. It doesn't say that. But the court seems to be more willing now to perhaps read these expressions into the Constitution. But of course, this is this would be quite an exceptional case, right? It has to be absurd or arbitrary, so absurd or arbitrary that the framers could not possibly have contemplated that this would ever become law. Like the courts are abolished, or judicial review is abolished entirely. You know, things like that would be very drastic. Anything less than that is hard to know. So the laws relating to defamation and scandalizing the court have been found not to infringe the right to free speech in previous cases by our court. There have been no significant constitutional challenges yet to the legality of the Broadcasting Act and Political Donations Act, so we don't know. But at the moment, it seems that such challenges are probably unlikely to succeed, given the way in which Article 14.2a has been drafted and, of course, interpreted by the courts. Therefore, much will depend on how or whether private individuals turn to the law. Obviously, if no one brings you to court for defamation, then no problem. But if someone chooses to do so, then it's going to be quite hard to get out of it. And how government enforces the laws. I'm not aware of any situations of websites relating to political matters or religious matters being ordered to close down, but perhaps there are just not publicized. Bloggers, we do know, have been threatened, of course, with defamation, contempt of court actions, and website owners have been gazetted as political association before. So one question which we, of course, we could ask ourselves is, do any of these laws require modification to allow for greater freedom of speech and so on? Well, at the end of the day, knowing some of these restrictions, you should blog legally, trying to comply with as many of them as you can. Use sense of sensitivity and common sense, and be aware of the potential issues. Happy blogging. Thank you.